pretty sure that was in the fact pattern.
No, I think they wanted them to all rotate through the 4 different jobs. I don't think she wanted to.
Yeah, with respect to Williams and Toyota, I'm not sure she wanted to take the more labor-intensive work. I think what some would argue she wanted to do is sort of cherry pick the easiest parts of the job here and decide that as long as those don't bother me, I'm pretty good with coming to work, and beyond that I'm not going to unless you make some level of reasonable accommodation. So I'm not sure that that's correct.
Petitioner announced it wanted the...
Petitioner's Toyota.
Yes.
Yeah, they're the ones that asked that despite her disability, we want to modify the assignments here so that she rotates just like everyone else with some of the more difficult parts of the work that has to be done on the line. Is that fair if Toyota's argument is, listen, no one wants to do this job, even if you don't have physical limitations. No one wants to do it. But if she doesn't like it because it's too intense, it's too much work, it's too hard, doesn't mean she's disabled within the meaning of the Act, and it doesn't mean we have to do anything for her.
Well, don't you have to be able to do the job anyways? Like before you can get accommodation, you have to be able to do the job.
Otherwise qualified, who with a accommodation can perform the job.
For example, like if you're a cashier standing up and they give you a stool, something like that.
Correct. But first you've got to decide that she's disabled. And we looked at this with respect to Casey Martin, we looked at it with respect to McGinnis. To what extent does it affect a major life activity? And that's when we start to think about this. I mean, she can work, she can't do, is that what that means? As long as you can do some work, the fact that you can't do all work doesn't mean you're disabled? She can't do this all day. Okay, my guess is probably, as Jim points out, we weren't made to do that all day. So that in and of itself isn't disqualified. In and of itself doesn't mean you're disabled. Not within the meaning of the Act.
Not according to the court. No, the court said manual disability involves a class of manual activities, not major life.
So the court refines it to a class of activities. This being one of them.
But also, if
Go ahead.
Congress intended everyone with a physical impairment that precluded the performance of some isolated, unimportant, or particularly difficult manual task to qualify as disabled, the number of disabled Americans would surely have been a much higher. So then they went on to say people who wear eyeglasses would be considered disabled.
And so therefore, while she might have a disability, it's not within the meaning of the Act?
No. The court said this is a mere impairment, and having a mere impairment doesn't mean you're disabled.
She's got an impairment. The impairment, while, would you say it's significant? I was going to say, while significant, still doesn't bring it within the meaning of the Act.
I think it's significant, but they say it has to affect a major life activity, and based on their language, the mere fact that you can't do your job, this job, is not a major life activity.
You can't do a specific job. The fact that you can work doesn't mean...
She can't work. That's the argument that failed too. The doctor put her on a no work status, so she has to lose the claim because she can't otherwise do the job. You know what I mean?
Go ahead, what?
Well, I mean, that's not... She came back when she could, and then they put her on this team that did the 2 tasks out of the 4. So...
No, but at the end, she went back to the doctor. The doctor said, you are on no work status. So then that's why the court said they failed their claims because...
And then they eventually fired her.
You know, yeah, they you know what I mean?
Well, it's... But the court said that it's an impairment that prevents or severely restricts the individual from doing activities that are central to most people's daily lives. And I think where the circuit court...
That's on bottom of 88, top of page 89.
Yeah, I don't know the numbers.
I mean, I wrote, district court also reject response claims in violation of ADA and Kentucky Civil Rights Act because even if the court assumed she was disabled, the doctor put her on no work of any kind, restriction.
The language Marsha was reading, just the full part of that says, major life activities thus refers to those activities that are of central importance to daily life. in order for performing manual tasks to fit into this category, a category that includes such basic abilities as walking, seeing, and hearing. I mean, at least initially, as the Act was designed, we're talking about going to the core of what we would see major life activities. The manual tasks in question must be central to daily life. If each of the tasks included in the major life activity of performing manual tasks does not independently qualify as major life activity, then together they must do so. And then it goes on to say this all needs to be interpreted strictly, probably at least in part, because as what Jim said, is to the extent that we interpret this liberally, we're going to find that who doesn't have some limitation then that might fall within the meaning of a disability and then might mean that they need accommodations under the Act. I look at this though and wonder whether, I mean, is the result just here? I mean, she's injured, at least in part, from working for them. She goes through a process, she comes back, she does have some disability, and at some point when she comes back, the job is made significantly more difficult. No?
I think it was unreasonable.
Huh?
I think the decision was unreasonable. I also think it was very unfair in the fact that when she was hired, she was supposed to do two things. Her job changed in the middle of her employment. And the mere fact that she developed these problems on the job, I think Taylor could have said, okay, just you do these, now the other two will require you to do, but we may not pay you as much as we're paying the other people who's doing all 4 jobs. And I think that would have actually been a good solution.
But tell me from the company's standpoint, if I can't, in operating my plant, make changes to the jobs that people have to do to try either to improve it, improve morale, or improve just performance, what kind of company am I running that I don't get to run the company anymore by making changes on a regular basis? I mean, if you're not a contracted employee with clear, specific work to be performed, your boss can change your schedule, can change your work at any time, can't they? Obviously, if you qualify under the Act, she has the right to have some level of accommodation if she's otherwise qualified and disabled. But beyond that, the Act doesn't mean that the company can't run their company the way they would otherwise, does it?
No.
I mean, I don't disagree with Henry that Everett, that it's at the end of the day, it's harsh, isn't it? I mean, she's likely not going to be working there any longer. But that's...
I don't think they can change in the middle, because when I worked for Wells Fargo, before we could fire anyone, human resources would vary a whole bunch of questions before we could fire anyone. They would say, did you change her job during the middle when she was hired? Can she do something less? Can she do something different? Because which we learned that their job was to protect the company and not the employees. We can fire them because when they go to unemployment, the argument is going to be, did you change her job? And if we say, yes, we changed your job, then they qualify for all the benefits that unemployment provides.
Well, they may qualify for unemployment. Doesn't mean you get to sue for wrongful termination or anything along those lines, or violations of the ADA. It may well be that they get unemployment. Huh?
They might have to pay a severance package in that case, Wells Fargo.
Well, maybe not. If you don't have terms of a contract, if you're an employee at will, I can fire you at any time I want. I can tell you your job assignment is different, as long as it's not for a discriminatory reason, as long as it's not ADA or Family Medical Leave Act issues. They don't have to pay you anything other than what you're entitled to, right? You're an employee at will. And most of us likely fall into that category. Unless you've got a union contract or a specific contract with your employer, they don't necessarily have to pay severance at all. Now, I don't know whether she's got some additional coverage through, I would imagine there may be some union and the like here at work, you would think. But that's a different story. Wells Fargo, they may have their own company policies that you also can change the terms of employment through a company manual and the like. So there are other things that may be at work. But for a lot of folks, you come in tomorrow and they say, hey, you need to do X instead of Y. You're going to be doing X if you want to continue to work there. That's, as a general matter, the employer has that right to operate their company the way they see fit, as long as there's no discriminatory motive at work.
A lot of big companies have policy now, though they try to be in line with, unions and stuff like that, but
Well, with the union, they don't have a choice. They're going to have a union contract, but
even without them, they have a lot of big companies that have policies, like, oh, you have to be written up, like whatever their policy is.
well, usually they're going to have a process where they're going to document before termination so that you can't come in with all these good evaluations and say they fired me because of ADA or because of FMLA or because I asked for this or that or because I'm a woman or because I'm over 40 or whatever it is. They're going to have a process to protect themselves more than they're looking to protect the employee. And a lot of companies don't fully comply with either the Americans with Disability Act, the Family Medical Leave Act, and the like because they find some of the process cumbersome and problematic.
Shouldn't it matter, though, that her disability was developed on this job?
Well, that's where the fairness struck me a little bit, the unfairness struck me a little bit, right? Is that it's the job that created it. Well, let me ask you, does she have a remedy then? What would her remedy be?
Workers' comp.
Yeah, right? She still has a remedy. It'd be workers' comp in all likelihood, right? If she can't do the job because
She settled for that workers' comp already.
Well, did she...
She already used that remedy.
No, but again now, I don't know what the terms of that agreement were, whether she's waived any future claims and whether she can come back and look for...
It says it. She did, I'm pretty sure.
That she waived everything going forward?
They let her come back to do with like the job she wanted, and I forget exactly, but I mean, she did settle it. It said, let's see.
I know she settled it, but I'm not so sure she settled it as much as at some point then returned to work.
No, she like contracted to get that job she wanted when she settled.
They settled and she returned to work. Under Section 1, second paragraph.
Yeah, it says the parties settled this claim and responded to return to work. It doesn't tell us what terms were.
But I mean, is the company really going to bend over backwards for someone with a limited skill set like that?
What do you think?
I think no.
And I think that's right too.
She's replaceable.
What?
She's replaceable.
We all, for the company, we're all replaceable. Right? And I can't have employees picking and choosing which parts of the work they want to do on a line because no one is going to want to do this. If that's the choice they get, then I got trouble because from a policy standpoint, there's a number of people that are going to find that they're injured at work, they're going to leave, and then they're going to tell me that they're, in the future, they can't do portions of the work they want to do. I think that's frankly why the company decides they're taking it all the way to the Supreme Court of the United States. It can't be because we've got one little employee who simply says, come on, can't you do something here? I think what they're looking at here is the slippery slope, worried about how many others will say, geez, this part of the job is too difficult. And so then either we're going to have to pay people a premium to do the job, and obviously from an economic standpoint and a competitive standpoint they don't want to do that, or we're going to have even more people claiming they're disabled and seeking accommodations out. Either way, it's going to cost the company money. I think, to me, that's the only reason they take it as far as they do. In part, I think they're worried about the precedent this would set. If it can be occupation and task-specific disabilities, the fact is that can cover a wide range of people with a wide range of problems. Go ahead.
But doesn't the actual language of the Disability Act say it must be permanent or long-term? I think I saw that somewhere.
I'm not sure that's the language that's still there because, frankly, you would have to make accommodations for an employee with a broken leg, even though that's not going to be permanent. I don't know whether that language is still within the Act.
The language doesn't say that. The court interpreted substantial as meaning that.
Yeah, and I think the modifications that came out within the last few years, to some extent, because the cases were all over the place, has changed a bit. It hasn't changed the interpretations, but has changed the Act so that those interpretations aren't likely going to be the law going forward, because obviously there are some things, some disabilities that, while temporary in nature, still might last 6 months, 9 months, and may be relatively easily accommodated.
So they do allow them now.
Yeah.
If it's not long-term.
Go ahead, Brendan.
I think a key part for the company's longevity is to be able to remain competitive. And in order to be competitive, you need to be able to make the changes that you need to make within your staff, the resources and different things like that to stay ahead, to stay competitive. So, I side with the company on that. They need the flexibility to make those decisions. Otherwise, everybody's going to be out of a job.
Well, but is that what your feeling is that she really doesn't classify as a disability because she can work, even if she could no longer work at Toyota? She's going to have to leave and go somewhere else because she's still capable of working. She's just not capable of doing all the tasks Toyota wants her to do. Because she's out of work then, for Toyota at least. That's the way it goes.
Didn't work that
The
yearly.
fire department says you got to lift 200 pounds and you can't. Out.
I don't want that
That's
firefighter
reasonable.
coming to my house.
The last one is reasonable.
Huh?
The fire department one is reasonable. This one is not reasonable.
Exactly.
Well, why do you say this is not reasonable?
It's one person. I mean, it doesn't say how long this person has been there. I mean, the task force.
I got the impression it was a while, and that's what made me sympathetic. Huh?
I think she said like 5 years she was doing that working with pneumatic tools, something like that.
Go ahead, Harold.
I mean, if it's just one person doing this one task, that your job won't change. It's repetitive, it's boring, it's mundane, it's doing the same thing over and over again. Seriously, one person, you couldn't just make the exception for this one person.
But then it's gonna open up a work for everybody else.
I mean, that's why they fought it, just
Yeah.
to end up happening.
And what do you say to the next person? You know what I mean? Like, oh, too bad, we just let Sally do it. You know what I mean?
Each person after that has to prove they're
Yeah.
disabled, so it's not like it's just like,
Well,
oh,
she didn't
my arms
prove
hurt
it.
too. They have to
It's
be
not
able to
about
do
that, it's about the
Yeah.
fact that, yeah, she's disabled, doesn't matter what job she's gonna do with her hands, it's still gonna be there. She could have been reasonably accommodated.
Well, but again, we don't have to get to the stage of accommodating her if we don't feel that she's got that major life disability, and that's where the court really dumps it out here, is they're saying, oh, listen, we know she has a disability. She has a physical impairment. We're saying that doesn't qualify under the Act here because it seems to be difficult task specific. So she can't do difficult tasks. A lot of people can't. That doesn't make them disabled.
She can brush her teeth.
Well, the court also said that she kind of did herself in because she kept insisting that she could do the first two tasks, but not the other two. So I think that was a key part.
Well, but again, I don't know whether that's quite fair because
Well,
she's got to be otherwise qualified too, though, right? So if I can't do any of the tasks, then how am I otherwise qualified at all? But what you're saying is, well, she can work. She just can't work all four of them, which means...
Then again, she can be reasonably accommodated, but the employer does not have to go out of their means in order to accommodate her.
They don't have to, and as you guys are pointing out, they are choosing here to do zero for her
They don't have to.
because they don't have to.
I think the court treated her worse than Toyota did.
Said what? What did you say?
I think the court treated her worse than Toyota did. Yeah.
Well, what about that?
I think the court would have.
But so then how would you then change the disability interpretation?
I mean, the court said playing with your children is not a major activity. Yeah. It's like, seriously.
I agree, but I think they kind of thought she was like full of BS. You know, like, that's why they kept saying like, oh, well, she can brush her teeth, she can do her hair, she can do this, and that's why they had to come up with something. You know what I mean? I'm guessing. You know,
You can't measure a disability if you can brush your teeth, play with your kids, or whatever. That's unreasonable.
you got to draw a line somewhere.
The measure should be whether you can do the task that you're assigned to in your job versus the other people who can do it. It shouldn't matter that when you go home you can do this or you can stand to watch your kids play.
What do you do about all the fake claims? How do you discern, you know what I mean, all the fake claims?
That's why you have doctors to prove that yes, this person's disabled.
But sometimes there's no view. That's why a big problem. Like they're like, oh, my back hurts, and they can't find anything wrong. And some people really are in pain. You know what I mean? And you know what I mean. And others aren't. So there's really no way to like discern. You know what I mean?
I think we're confusing, in my opinion, a disability with a desire. To be disabled, perhaps not to be able to do what normal individuals can do. In this particular case, with regards to the job that she wants to do, that's what she desires to do. She's not disabled as far as being able to work somewhere. She is claiming that she's disabled to do the job, this particular...
A difficult job.
Correct. I mean, listen, if I want to be a model, that's not going to happen, but it doesn't mean I can't do another job. I'm not disabled because I can't magazine.
Realistic Photoshop.
There's a difference between disabled and unable.
Well, let me ask you, with respect to the point, because we could say, and I think it's not unfair to say, boy, this is a relatively strict interpretation, but if we look at what the Act talks about and what the early interpretations were, we were talking about things central to daily life. Walking, not walking fast, walking, seeing, hearing. I mean, basic functions that we can do, that we expect to be able to do, brushing our teeth, taking care of ourselves, basic functions. This certainly doesn't fall into that group. She can work. She can't do difficult tasks. A lot of people might not be able to do that. And so how far down that slope would you be willing to go if that's the case? Because if you're going to give her the latitude to say, well, she has a disability. Well, you can't walk at 5 miles an hour, or you can't run a mile in 6 minutes or 8 minutes or whatever it is. Those could be disabilities too, even though we all have different abilities to do different things. I mean, she can work. She can't work at this difficult task. It's not disabled, maybe unfair, maybe kind of lousy for Toyota to do, having put her in this position to begin with, but they're within their rights to do it, at least as this court says it. And I do think the court this is a relatively strict interpretation of what it takes to be disabled.
I just think it's easy sometimes when people look at giant companies like they're like a demon. And I mean, if you take it to like a small business where, all right, perhaps the court says, okay, you're not going to go bankrupt making this accommodation, but maybe, it's going to hurt the business so bad that it's going to deeply hurt their profits. I mean, you could look at it that way and say, geez, you can't make an accommodation for everybody. And would they mention, if she was in a union, wouldn't they would talk about collective bargaining agreement, wouldn't they, in this? And
No, I don't think so, because my guess is the activities likely would be bargained for or whatever, and she's not saying that it's not part of the contract that she would have to do it. What she's saying is, I don't care what that says, I'm entitled to an accommodation if I'm disabled. The collective bargaining agreement can overcome her rights under the ADA.
Wouldn't they go for a strike for her? Or I don't know. I mean, wouldn't there be, I don't know.
As you started us off here, you say we've got a malingerer who's looking to not do what all the rest of the union members have to do. I'm not going out and strike so I can do twice the work, twice the crappy job. No, right? I mean, that's the problem from the standpoint of the company. This is not a job anyone would choose to do unless I'm getting a premium. And that's, I think, the problem from the company standpoint.
What about the poor other people that are doing the other two jobs that are horrible? Maybe they're like, nice, we get to rotate with that chair job, you know what I mean? And now she's saying no, I mean.
Well, but that is the problem. I think they're looking at it from the global standpoint is here. If we let her do it, there's going to be a bunch more people saying, I can't do it either. I mean, I don't think anyone wants to work on an assembly line.
It's not just going to take your word for it. You're going to make them prove that they can't do it.
Oh, sure. But my guess is it wouldn't be that difficult to get a doctor to support, as Jim has already pointed out. Doing this for 8 hours a day is going to put stress on your shoulders and likely cause some level of...
there's no way she's the only one that's had this problem doing that.
Right.
No, I mean, if this happens, they're screwed because they got to put all these people in. Where are they going to put them? They have no skills.
Well, why did they change the job so that all 4 positions rotate, if not the likelihood that someone's saying, I'm not doing this all day. Why? This is crazy. This is difficult. We can't keep doing this. My guess is they changed it to try and spread the chores around a little bit, and now we still have a problem.
Do you think the number of carpal tunnel and back injuries to workplaces from 1975 to 1995 went up or down?
Exponentially, right?
So what does that tell you? I mean, it's not that it's not real, it's just that you've got a lot of false claims.
Whoa! Well, maybe the claims are generated in part because of the technology. Did you give that any thought?
What do you mean? Oh, we didn't know. You didn't know yet. Well, I
No, not that we didn't know. Is that the manner in which we went about doing things changed from the 70s forward as well, right? I mean, are there more claims now? Sure, but we're doing things differently. How many of us would have been on a keyboard regularly in the 70s and virtually now can't live without one?
Yeah.
No matter what you do, right? Virtually. So I don't think it's all.
I didn't say it's all. Like I said, I'm sure. Like I said, it's really. I don't have a figure or anything. I'm just saying. You don't think there's any false claims?
That's not what you said. You attributed the entire rise to false claims. We have the tape, just so you know. Are there some? Sure, right? Obviously, there's going to be some, but obviously, I also think that things have changed. Listen, let's be honest. See, my perspective is a little different than you guys because I tend to represent people against companies. I find some companies, despite they should know better, they don't care about what some of these requirements are because they just don't care. They'd rather litigate than fix bad company policies and to accommodate at times. I had one that was shocking to me by a very large company to the extent that they didn't care about what the law required and did not want to do anything. And I think in part because, okay, if we start doing something for him, Sally's going to want this and Joe's going to want that, and it's just so much easier for their moron managers to say, no, black and white, we don't do this, we don't do that, you do it. And so from a standpoint of running the business, it's at least temporarily easier. It's more costly at the end of the day, but then the process oftentimes is, and it really often is, and I can't convey this strongly enough. Once the claims are made, often than not, the companies simply stonewall it to death with the expectation that you got to come back to work sooner or later. If you don't come back to work, you're going to go broke and you can't afford your lawyer or the cost of this anymore. So to some extent, as I think Everett said, that the court victimized her as well. Well, the process will often victimize those people as well, simply because the process is long, it can be very expensive, and the expectation is how long can you be out of work? I mean, this went all the way to the Supreme Court of the United States. This had to cost an awful lot of money. Likely she didn't have it to get there. Part of it is they're going to wear you down, and unfortunately that's part of the litigation strategy of a lot of larger companies. When there are violations, here there aren't violations, and I think in part they were trying to set a standard to make sure that other employees would do what they needed to do. Let's talk a little bit about EEOC versus Waffle House. Let's talk a little bit about the agency process as well. The Equal Employment Opportunity Commission, the Mass Commission Against Discrimination, there are places where you can and in fact must go to lodge some of these claims. And especially if we're talking about the failure to comply with the Act and therefore discrimination claims if you're disabled, we now have to recognize that these claims have to be advanced in days, not years, because oftentimes when we talk about statute of limitations, we're talking years. But if you wanted to lodge a claim with the Mass Commission Against Discrimination because you feel you've been discriminated on the basis of your disability, then you have 300 days to file that claim of discrimination, and it must be filed with MCAD before you can go to court. You can dismiss it once it's been filed, but you must file the claim with the Mass Commission Against Discrimination. And the sooner you file it, the better, because from a damage standpoint, those 300 days, it's only the damages that would have occurred within 300 days of your filing. And that can get a little sketchy sometimes if you've got a case that's gone on for years and years, and then ultimately there's some significant action that your client decides that they can't stay there any longer and go forward. Well, the fact is you might only be recovering for the damage within the 300 days of the filing. So you've got to recognize that there are agency requirements and there are very limited time periods to file this, but both the EEOC and the MCAD are places that can assist you in pursuing these claims. From the EEOC standpoint, if you file a complaint, if your client files a complaint with the Equal Employment Opportunity Commission as a result of the problems that they've had, the EEOC will investigate and the EEOC will ultimately issue a report. To the extent that the EEOC finds in your favor, that's obviously extraordinarily helpful in moving forward, not necessarily collateral estoppel, but the fact is it helps to convince others of the significance and seriousness of your client's claim if you've got a finding that supports that the actions that were done were improper. From the standpoint of the Mass Commission Against Discrimination, you're required to file the claim with them, but oftentimes we don't wait for them to issue a decision. You're required to file the claim with them, but then you can dismiss the claim and proceed to court if you would prefer. As a general matter, there are cases that the MCAD will take years and years to do an investigation. Ultimately, they'll have a hearing, but we're talking potentially years because the backlog up there is significant and the pace at which they proceed is slow. So oftentimes what most people will do is file the claim with them and then dismiss the claim and proceed to Superior Court, simply because if I'm going to wait, I'd rather wait and move forward in court with my discovery and everything else, and then at least I'll get to trial within 2 years. I might not get a hearing before MCAD in 2, and then I still may have to go to court after that. So the process, while in theory the process should be more advantageous and beneficial for the plaintiff, it's really theory at the MCAD. Occasionally you'll see them issue a decision that talks about, a big judgment or whatever, a finding, a fine, whatever. But in my experience, it's rare, and the problem is you just don't have the time to wait oftentimes. Your client's likely out of work. There are other pressing issues there. You got to move. But you've got to remember that in many cases you have to file the claim first.
So if you took the case and then the MCAD says, oh no, we don't think it's meritorious, like halfway through the book, can the defendant bring this up?
It's a question of whether the finding is admissible. The likelihood is, because it is somewhat of an adversarial, the EEOC is not an adversarial process, it's an investigatory process. But it's very, very helpful to have an EEOC finding, obviously, in your favor. But the MCAD is an adversarial process. And so there's an argument that finding could be used as collateral estoppel. And so therefore it is admissible. By statute, I believe it's admissible in court as well. So the fact that you've got the case, they say no, but you still think you've got a case, doesn't mean you can't sue. You can, but that finding will be admissible.
You can only collect for the 300 days. If it goes all the way up to the Supreme Court?
No, but 300 days for filing plus what that follows. Once you file, your statute of limitations is told. But for instance, I have this case against this big box retailer. It went on, the treatment went on, his treatment at work probably went on, my recollection is 3 years, till finally he couldn't take it anymore. He was actually hospitalized in a psychiatric facility, and then finally filed. But in filing, the stuff that happened in year 1 and year 2, even though it was important to the development of it was important to understand how stressful it all became, technically he couldn't recover for year 1 and 2. He technically couldn't recover for even the first 60 days of year 3 because all of those actions predate 300 days of his filing. It seems odd, but the case law is pretty clear in Massachusetts that that's what it is. And what becomes problematic, and I didn't file this case, I came in after the case had been filed. What's even more problematic is that there's an argument, even now you know this, okay? People don't file right away even when they feel they've been constructively discharged, or that this horrible action is filed. They come see you, and you sit and play with the file for a little bit. And then you get your meds, and you get all your support that you're supposed to get. And then at some point you file. So you're not even filing on that, you're not even filing within 300 days of the act, if that employee has either been constructively discharged, terminated, or whatever, because there's some time that you're losing simply to proper procedure. And so it becomes problematic. That case was actually filed on the 300th day following his constructive discharge. 300th day. They couldn't have cut it any sooner. I didn't file that suit.
So I'd say you lost the 300 days just because it was filed on the 300th day.
Yeah, the days that followed, you weren't going to be able. No, you could get it You could get it from day 300 down to day 1, but you couldn't recover for the 2 years of really pretty brutal treatment. Except you could. I mean, okay, you can't technically, right? But he's still totally and permanently disabled as a result of these crippling mental injuries that they inflicted on him. And technically, it all happened on that very last day, because that's the day he snapped and couldn't take it anymore. So, technically all this, we're not recovering for all the crappy stuff in years 1 and 2 in the first 60 days, but his damage is flowing from here forward because he's now permanently and totally disabled. It creates a problem, though, from the standpoint of trying the case, because you'd argue that a lot of this earlier stuff may not even be relevant then, or I would if I were them. But there's
I don't know what they did to this guy, just hearing you say that. But
it's nothing, well, it's not nothing. I mean, they ridiculed him for a couple years. All he wanted, he was OCD. So he had his peculiar ways, but his ways manifested themselves in cleanliness, which for someone dealing in the food service industry, you wouldn't think would be a problem. But the company saw it as a problem because he was seen as picky, and he was kind of a pain in the ass at the times, no doubt about it, but he was within his rights to, he wanted clean uniform more than once a day. And he was dealing with food service. You wouldn't think that, because by the way, his clothes would get covered in blood. He was a meat cutter, okay? You really wouldn't think, because most of us wouldn't want to be working in meat and blood-soaked clothes either. It was odd that you wouldn't accommodate him simply because it sounds like good business that. Not that he was a great worker, by the way. It was a great worker. The evaluations were all terrific up until the time he started asking for what to me seems like ridiculously reasonable accommodations. But then it all turned, it was ridiculous. It was really, you could not believe what happened by a Fortune 1000 company. Go ahead.
How can the MCADs finding the users collateral estoppel if they give it the option to just file a dismissal right away and go to court?
Well, that's why, because if they go through with the process, then there is a hearing by a hearing officer. Witnesses are called, testimony is received, and they ultimately make a finding. It's because it is adversarial. You can call witnesses. There is a record of the hearing. Stuff we talked about last time in Civ Pro is that if the administrative process has the types of due process protections one would normally expect. A record, the right to call witnesses, question witnesses, compel the production of evidence, and the right to appeal. If all those types of safeguards that we would expect in a judicial process are present, then that also can have preclusive effect going forward. And so that's why some people don't want. That's why another reason why you don't want to wait, because I don't. It could be any of us be the hearing officer. I don't know what. I don't know what abilities you guys have to discern some of this. I'll take my shot. I'll take my shot in court, and that's why a lot of times that's why it doesn't make sense why there is such a ridiculous backlog, because except most of them would be pro se, and so then that process gets slowed down as well. Let me get back to the case here, because there's a couple things I want you to think about. EEOC, in this case specifically, a lot of employment agreements now have required arbitration provisions in them. It's not just your union contracts and your public employees. A lot of private employers do this. I tell people, this was a decade ago, my son came home from, back then it was Circuit City, for a summer job when he was 16. He had a contract this thick for, what, $7 an hour that they wanted him to sign, waiving every possible claim he could have in the world, and agreeing that arbitration was the way to go. I was actually with someone this weekend. They said the company is just now, they just did this demonstration for them. They showed them a video, and despite having been an employee for about a year and a half now, they want her to sign an arbitration agreement on any claims going forward, which indicate, well, as I told her, it indicates to me that the company must have some issues, because a lot of these companies have wage and hour violations that they're now, and potentially some discrimination claims that they're trying to dodge. So I would not sign it at this point, but she may well lose her job. But at any rate, the companies are going with the required arbitration provisions, and from your standpoint, it's take it or leave it.
Violate something by making you sign a contract to keep your job, isn't that kind of like unconscionable? I mean, you're not really contracting to work at that point, are you?
Well, see, what surprised me, and again, you'd know this, you'd know this company. What surprised me is they hadn't done it already, because the trend for the last, seriously, this was probably 14 years ago when my son was doing it. The trend for a long time has been to require these provisions within virtually any agreement, so that you don't get a jury trial and you don't get court process at all. And so to me it was surprising that they didn't do it upon it. But again, it goes back to this point that I said to you earlier. I can fire you tomorrow, right? I can fire you.
Something like discrimination. I mean,
well, if it's not discrimination,
right,
I can terminate any employee anytime I want. Right? You don't have a right to have your job unless there's some contract or that you have, or unless you have some union provision beyond some statutory protection. And most employees at will don't fall into that unless they then hit a protected class by disability, by race, by age, religious beliefs, or something along those lines. And not just, okay, so now you're in a protected class. You still got to show that that's the basis as to why you're being let go. And it's, again, companies are usually pretty smart to say, let's not get rid of the old broad. Let's get rid of the person that's not performing properly. They're smart enough to hide their dirty little secrets. So I don't think she's going to sign it, but it will be interesting how it plays out. I meant to research it. My guess is the company must be having some issues, because it seems odd that, and the way in which she described it to me, there's sort of a big thing. They showed her a video. They said, we're going to pay you to watch the video. You're going to stay here for the hour and watch the video, and then we're going to ask you in a week to sign the agreement because you can't sign it today. It sounds like the lawyers have laid out this procedure that, frankly, I don't even know why they need a lengthy procedure like that. Might have been better off saying, here, take this home, bring it back tomorrow signed, or...
They probably would all sign it.
Yeah, I know. Because now, it was such a big to-do. That's why she was saying, go ahead.
Doesn't this case give a way around the binding arbitration?
Yeah, let's talk, well... well, potentially if you're disabled, and it may not be a way around your waiver of your arbitration rights, but that the company still nonetheless, the EEOC may still have rights that you don't have the right to waive. And that's what I wanted to talk to you a little bit about with the case. and Darius loves this Waffle House, and I don't get it, by the way. Huh?
I'm with you on that one. I totally don't get it.
He used to talk to, when we get to North Carolina, we'll go to Waffle House. Oh, it's the best to get in there. Say,
Which one? There's one on every corner.
I don't get it. I don't get it. But at any rate.
Yeah.
Huh?
Okay. The other one I don't get is crackers.
I've never been in there, but he did take me to Waffle House one time and was not impressed at all. So anyway.
I suppose you have to like waffles first, I guess.
No, they have everything. It's not even, I don't think the waffles are such a big deal.
You're going to go to Waffle House and not get a waffle? Yeah, that's why I don't like.
He was right, though, on the chicken and waffles at Gladys Knight in Atlanta. I got to give him that. So at any rate, they have a mandatory arbitration agreement. You want a job, you sign it, and if you don't, we don't care because you're not getting the job. Which, by the way, I know that sounds offensive to you, but the case law is clear on that. Go work somewhere else. You don't have a right to the job. Case law is clear that you got to sign. If you have, there's no unequal bargaining power argument. There's none of that. There's actually a lot of federal cases that say there's a federal statute that encourages parties to arbitrate their disputes, and there's ample case law that says no, because I've done it to try to get people out of the arbitration agreements in federal court, and they say no, tough luck. The law significantly favors it. I think it significantly favors it in part because it's less work for the court. But they're everywhere. And it's not just the arbitration, but the location, payment of it. There's a whole host of issues that are attached to it as well. So at any rate, he never initiated arbitration proceedings, but he did file his claim of discrimination with the EEOC, alleging that his discharge violated the Americans with Disability Act. The EEOC did the investigation. They attempted to conciliate. See, that's the other thing that's interesting to think about, especially an agency like the EEOC, which does actually move pretty aggressively and pretty quickly. It saves your client money if we can work it out there. They will attempt to conciliate. They will give you real advice about what they think the strengths or the weaknesses of the claim are. Oftentimes people don't necessarily want $1 million, and they're not likely to see it either. What they want is their job back, or they want an accommodation, or they just want to be treated respectfully by the company. And so to the extent that you can get that dialogue working, it's a positive thing. The problem is, I think, most companies, once an employee has done this, they're not going to keep them back forever. It's just like we saw the Toyota case where she settles the claim and then they jam her up afterwards, some would say. So it'd be nice if we could resolve it this way, but I do think you have to worry about going forward. How do you make it somewhat bulletproof that they don't come back? You don't replace a strong case with a weak case down the road that shows very little discrimination, because now you've educated them about what they need to do, and they'll just wait till the claim is not as solid and they can terminate the employee or make the conditions so unlivable that the employee will move on. And that's always a worrisome, is settling early like that, is that how do I make sure I can construct an agreement that I can enforce down the road, because otherwise my back is exposed on that. Yep.
How are these mandatory arbitration contracts not seen as unconscionable adhesion contracts?
Go somewhere else.
Go somewhere else.
Your right to bargain, you work. That's why they have unions.
But forget the unions, because the union's going to bargain for you. There's actually some strength and some real negotiating. But I'm telling you, my 16-year-old son goes to Circuit City, so now it's called Best Buy. He wants a summer job, $7 an hour. They give him a stack of documents, yay thick, tell him to read it and bring it back signed if he wants to work that summer for $7 an hour. He doesn't have a choice. If he wants to work there, he's going to sign them. And if he doesn't want to work there, he's not going back with them signed. And the courts don't care that that's the deal. Is it unconscionable? I mean, the argument is no one's holding a gun to your head and telling you to sign it. And you know, in a lot of, what?
Yeah, but you have a right to work. It's in the Constitution. So what if every employer says you have to sign?
Where's your right to work in the Constitution? Life, liberty, pursuit of happiness. Work isn't even in there.
That's the Declaration of Independence.
So where is your right to work?
That's definitely. That's what he
Not
said.
all employees are going to say, employers are going to tell you.
But it's possible.
It's possible. If it happens, I mean, I guess you.
So what
I mean, it's possible for. I mean, you know, you can't make that up.
More and more are. There's no doubt about that from that standpoint.
For sure.
But so what? So go be self-employed. Go do something else. You know, listen, I don't. You didn't care about poor Mrs. Williams. I don't. It's not fair. It's not fair. You did. No, I do too. It's not fair, but it is the law. And you guys told me first class you didn't care about fairness. You care about the law. Justice wasn't important to you.
Everyone said that.
Oh, everyone said that? So it's not fair, but it is the law that...
A lot more protections now than there were in the early 1900s. I mean, you know, you could just, hey, you're working 14 hours. We don't want to shut the boilers off today. You know what I mean? Like, you know.
All of those mills were constructed so that if there was a fire, the floors would collapse, at least the exterior of the buildings, would they keep the buildings would remain intact so that they could then fix
I've
them.
never heard that.
No, it's true. That's terrible.
Never heard that.
So wait a minute. It doesn't matter whether we think it's fair. It is unfair, I think. But because especially, oftentimes people don't really understand their rights anyway. They're not going to be able to modify the agreement. But if you want to work, you're going to sign. Listen, if you want surgery, you're going to sign that form, right? Oh, informed consent? Yeah, I could die. Okay, I sign right here. That's what I do. Yeah, right? That's what we do, right? So fair and all the rest of it, that's not fair.
I would argue that I could die. I think it's different. Yeah.
Different than what?
Surgery consent is different than
Not eating?
signing your rights. Yeah, actually, yeah.
So what? It's better to have. It's easier to have one that says I could die than one that says, okay, listen, if I have a problem, I agree, we'll go to arbitration. That's not that unfair, is it?
Yeah.
I mean, huh?
Yeah, I think it is.
Why?
You're waiving your rights.
So you want to be.
But you're waiving your rights.
I'm going to waive my rights to work.
You're waiving your rights to work and eat.
Why
Agreed.
can't I work and have my rights?
You can, just not here.
Yeah, but what if every company does that, though? It's
Well,
possible.
It is possible now. Frankly, if you ran our company, if I were representing them, I would recommend that you do that. Why wouldn't you? Jury trials, that scares businesses to death to begin with, right? And plus the length of the process and the cost of what you guys charge in that process. Why would I want to engage in that? No. Let's go to arbitration. We'll do it quickly. There'll be no jury. And one way or the other, I've got a decision probably in 90 days. I'm done. Whatever happened, I know I'm done.
And they choose an arbitrator.
Huh?
No, you won't.
No, there'll be a process where there is a selection process for the arbitrator, and that's right. That would be worrisome as to how that comes about. So, usually, you know, but again, we can't negotiate it like we would in a business agreement. You know, a lot of times, if we were negotiating a business agreement, I'd pick one, you pick one, those two will pick a third, and we're done. Or we'll each pick 5. If any of them match, that's the arbitrator from a list available at whatever we decide. I mean, there are ways to do that to make the process more fair as well. Because you're right, you as the employee don't even understand the process of the arbitrators, but the company, if it's of any significant size, has probably been through this more than a few times. That's why they're picking the forum that likely favors them. But we got to do with the case here. So the question is, if he signed this, to what extent is that limiting? Oh, this in this case talked about the Federal Arbitration Act as well. And what it says here, and this is what I was just saying to you about federal law. It says the FAA, the Federal Arbitration Act, broadly provides that a written provision in a contract evidencing a transaction involving commerce to settle by arbitration of controversy thereafter arising out of such contract shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. That's really strong language. Right? Valid, irrevocable, and enforceable. So we might like it to be something else, but there's federal language in the statute. There's also numerous federal cases that significantly encourage the resolution of that. And also, as it says later on in the case, oftentimes these are coupled with forum selection clauses and the like, so that the process is substantially altered and not necessarily in favor of the employer, but the fact is the employer has the advantage of the speed and the lack of as they would see it, the unpredictability of a jury resolving that issue. To the extent that he signed the agreement, he is bound by the agreement. To what extent can the EEOC nonetheless investigate his issue and potentially take corrective action as a result of what EEOC chooses, EEOC finds as potential violations? Can EEOC go forward even though he has signed his arbitration provision?
Yes.
Yeah, right. So you can't preclude them, and that language that result is pretty consistent with the notion that only the parties who have signed the actual arbitration provision are bound by it, because we've had that argument as well, as that they may want to bind individuals whose names appear on the contract only as officers of the corporation. And the argument is if they're signing as officers of the corporation, they haven't agreed to arbitrate their individual claims. And so that you can get some potential relief from as well. And then you have the dissent, which obviously Thomas and Scalia say, how can this be fair that they can go forward and get remedies on behalf of an employee who agreed to arbitrate any discrimination claims against him? Even though, as the language here talks about, it falls comfortably within the Federal Arbitration Act as well. But the majority says the EEOC isn't bound to the terms of that contract, only the signatories are. And even if he chose to try and waive EEOC's claims, he wouldn't have the power to do that. But again, the dissent places a great deal of emphasis on what this Federal Arbitration Act, and as it says towards the end of the dissent, that they've expanded the reach of this. The courts, federal courts especially, really like requiring parties to arbitrate their disputes. I think in part is because it lessens their workload. Lastly, I printed off for you some case studies that I found online that dealt with the ADA and the Americans with Disability Act, and then this just a quick little piece on the Family Medical Leave Act, which I think, again, these are remedies that you should be aware of, and you should, if you're working with businesses and the like, they should understand the potential ramifications of it. But again, just quickly, ADA is going to cover any company with 15 or more employees who are employed on a regular basis. Family Medical Leave Act requires more employees, 50 or more. So if you have a company with 50 or more, they've got to comply with both, obviously. And again, this is an area where some companies are concerned about how do they run their business and comply with these provisions, but you obviously have to comply with federal law. And so to the extent that someone has a serious health condition that makes them unable to perform the essential functions of their job, potentially we've got both ADA and Family Medical Leave Act issues that have to be addressed. The situations that follow were fact patterns taken from various complaints and the like. And as you can see, some of them start out relatively what we would have thought would be innocuously. We've got an employee who has seizures at times. And as we talked about, the fact that they could be mitigated at one point was considered not having a disability. But the language in the amendments and the like, there are cases as well that says that the person may well be considered to have a record of a disability or be treated as such, and therefore, with or without mitigating measures, she may or may not be covered under the Act. The greater the likelihood is she would not be, at least as they felt here. You got someone with depression. And now you've got issues. Once you're aware of these issues, the question is how to deal with it. And again, some of it's going to be Family Medical Leave Act, some of it can be ADA. And this raises another issue that they don't discuss. There are times where you've got a troubled employee and you're coming in conflict with the ADA as well as your obligation to make sure you have a safe work environment for the balance of your employees. And obviously you're not required to keep someone who's a danger to others, but you may also have some significant exposure then to ADA claims or discrimination claims as well, depending on what the nature of the person's problems are and the like. And that can become a problem as you try to think about dealing with employees that obviously some people feel uncomfortable with, but the fact that they're uncomfortable doesn't mean that they're the ones that the person with the issues is the one that has to go. You get a migraine issue. I thought that was kind of interesting. And at some point, even that alone could trigger what we call the ADA's interactive process. And what that means is that once you've been made aware that someone has a disability, there's supposed to be an interactive give and take such that you try and determine what a reasonable accommodation for that person may be, assuming that you can do so reasonably. And then there's a couple more here that I think you should look at. But obviously, any of these issues, as you start to think about them, when you start to have these red flag medical issues raised, you've got to start to think about how am I going to be able to do it and not expose myself to liability under the Act. And hopefully accommodate the employee such that you continue to keep the employee. But obviously federal law requires a fairly strict compliance with both of these acts. So I thought these were interesting because none of them are as serious as sort of the Toyota case, but they all begin to trigger the Americans with Disability Act and potentially your obligation to comply and engage in the interactive process. And even if they don't do that, they create Family Medical Leave Act issues that you have to make sure the employee is aware of as well. So that's it. Thank you.